The short of it is as of Friday, some of the biggest, legal research players, Bloomberg, Westlaw, and LexisNexis, all announced that they're going to be creating artificial intelligence tools to help with brief analysis. And as many of you who've been coming to this conference for many years know, this is actually the technology that Casetext won for Best Product of the Year, Best New Product of the Year for 2016. So 3 years later, we're now seeing major movement among some of the biggest players. And I think what it shows in some ways is that this is where the future of a lot of legal research is headed. A lot of the companies are invested very heavily and invested years into making this technology come to life. And that's something that really excites us. It really excites us that the little revolution that we started a few years ago is turning into something that is becoming much bigger. And I think as many of you know, we put together this as an opportunity to educate everyone about the strengths and weaknesses. Hey everybody, welcome.
Welcome.
The strengths and weaknesses of the different technologies, what they do, what they don't do, how it compares, how it stacks up, and gave everybody a forum to do this in a side-by-side educational manner. And at first, it actually looked like some of the folks from the other companies would be coming. Maybe they are. Yeah.
Never mind, it's just us.
Yeah. So it looks like now that we have to take on the burden of, instead of just showing our technology and letting them do the work for themselves, we will actually still live up to, as promised, as honest as we possibly can, a side-by-side comparison of the biggest new tools that are coming out from Westlaw, Bloomberg, LexisNexis, and from Casetext. And so that's going to be the legal robot battle. It's going to be, I think in some ways, given they're 8 minutes late to it, you can declare this a victory by. But
they forfeited.
In fact, we will now ceremoniously push the chair to an audience member. We did try. We invited them by email, in person.
How do we know?
Right.
Oh, we can bring receipts if you'd like.
Yes,
to.
I'd like to see evidence.
Yeah. I'm happy with that. There's a skeptical
well
bunch
aware
like,
of when and where we wanted to do this.
Yes. So without further ado, the way we're going to do this is we're going to run through everything that we know about the other products and some of the things that we really like about what they're doing, and some of the things that we think that might need improvement as they evolve their products. And we're actually going to want some audience participation because they've been very secretive with what these products may or may not contain or do. So if you know something that we don't, I think it's good to get that out here because the point of this is to educate everybody. And after we do that, we'll compare and contrast that with the original AI tool, Kara, the one that we made at Casetext, and we let you guys obviously decide for yourselves what technologies you think will define the future of this field. All right, so the main contenders in this. The first, and I think the one that deserves the most discussion right now, given where they are, is Thomson Reuters Westlaw came out, as Bob reported in his blog, LawSites blog, a technology called QuickCheck. So we'll cover what we know about QuickCheck so far with a few screenshots, etc. The first thing is that, like with Kara, you begin the technology by uploading a brief or memo. You must upload something that contains at least 1 or 2 citations. And it asks you this really interesting question at the very beginning, which is, are you checking your own work or are you checking opposing counsel's work? I think is a really interesting way of going about it. And as the name implies, the idea of the technology itself is to check either opposing counsel's work or your own work, right? To see, did I miss something? Should I be adding something? Should I be taking away something, etc. And so you begin by uploading a brief, and then the results screen will look something like this. This is the screenshot we got. And there's a lot of interesting stuff going on here. First of all, they recommended, and this is reported on, I think in Bob's LawSites blog, a total of 15 cases. They split out the cases they recommend by the headers in the brief, which makes sense, right? So they want to, if you want to dive into issue A or 1A in the brief, they'll say, here are the cases you recommend for that brief. And they recommend a few other things too, including briefs and memoranda, secondary sources, or other recommendations. You can also filter things by, like, can I see cases that have been frequently cited? that are from high courts, so I'm guessing state Supreme Courts, or cases that have come out in the last 2 years, right? And I think that's the basic idea is to, so for example, say you upload your own brief, and it has 3 sections, you want to bolster it by finding other case law. That would be the use case here. It's kind of a brief check. A few notes, again, I think from both the press releases and from the blog reporting out so far. One is that they claim that they encrypt and then completely delete the brief from their system. A really important aspect of security. In fact, that's something that we've been doing as well, from feedback from a lot of folks like you about whether we can hold on to documents on our servers that are potentially work product, right? Confidential work product or under seal, et cetera. And one of the things that's a little bit curious about that is how they then still know what the sections of your brief are if they've deleted the contents of your brief. So that's something that I think we'll address a little bit later, but that's kind of an interesting aspect of what they're talking about. Secondly, like we pointed out earlier, they try to help the recommendation system using flags like frequently cited, high court, or last 2 years. And before diving into some commentary, things we think are doing really well, and things we think we improve, anybody else here, anything notable you guys have heard about this product to educate the rest of the room? Or do we kind of cover it?
And who's here has seen a demo? What was it about the investments? Okay, so if there was something new, you guys would have known about.
Curious, did they allow you to make those screenshots and put it up there?
Those we got from blog reporting. So presumably they're out in the open. Yeah.
Like maybe my blog.
Yeah, probably from LawSites blog. Yeah. So some quick kind of thoughts on what we love and we don't love.
Okay, so first of all, we love that they're doing it. It's about time that they copied us on this stuff. This is absolutely where the direction of legal research is heading, and we do think overall it's a very good thing to see them trying to get into our fray. And there's some things specifically that I think they're doing that I really do think are nice and elegant. So one, the opening question of, are you making this motion or are you opposing it? I think is a fundamental dimension of context that's really important, right? It's adversarialness, right? And we have certainly been looking at the different ways that we're going to bring that about, and I think that shows a sort of a good understanding that when you think about an attorney's context, it's not just what are you working on, it's are you the plaintiff or the defendant, are you the movant, or are you responding to the brief. Now what's interesting, it's been very recent that Westlaw has been sort of releasing things and saying, by the way, this doesn't really have perfect recall, this is a feature that may or may not sort of work very, very well, but we're releasing it. So you saw that with their orange flags for the first time, where they said they think it's about 85% right. For case outcome, they've sort of said that now they're going to start telling you on a legal issue, does this case hold that the patent is valid or invalid? Unfortunately, without really digging into it, I wasn't able to really assess just how that's going. But to the extent they're starting to do that, I think that's a very good path to go down, because when you're an attorney, it's a very useful way to say, okay, look, I want qualified immunity to apply, so show me cases where that has happened, right? So that's really showing, I think, a sort of right direction. And, with the librarians, it's great because we can get in the weeds on this stuff and still, everyone loves. They're always telling me not to get in the weeds, but with you guys, if you get deep in the weeds. Subtle thing they do too is, so we will let you, when you upload a brief, say...
Weeds is good.
Yeah, exactly.
Maybe a t-shirt. Weeds is good.
Okay.
Legalize
Three
weeds.
comments, Shabir, you've used that. Okay. So one of the things we did, early on, in the original embodiment of CARA, it only showed you cases that weren't in the brief, right? And then because, and we'll get into this a bit more, we sort of expanded CARA to anchor a full research system, it would show you both. So they not only give you the ability to hide what's in the brief, but they can say, don't show me anything I've folded earlier or that I viewed earlier, right? So, we have glasses icons and things to show you if you've looked at a case, but I really like that they have a way of being like, only show me things that you have, I really shouldn't have seen already. I think that's a step in the right direction.
And show and filter also.
Right, exactly. We show, but they let you filter out those, which I think is a nice
You
step.
can even see that in their little screenshot, like viewed in the last 30 days as a filter.
Right.
You can use,
Right.
Which is cool. It's very cool.
Right. Okay, so now some issues, or not issues, but limitations. I mean, again, these guys they say they've been working on it from 2016. I don't know. I mean, they're showing a lot of good promise here, and I think there's a lot of things. There are some things I think fundamentally that they're going to have to get to sort of and start and doing different ways. One is, of course, it won't take a complaint, right? Complaints don't have 2 case citations in them. And, when you think about your context as a litigator, the complaint is that fundamental originating document that can do it. And one of the ways that our clients have really loved using CARA is to be able to drag and drop their complaint. And in fact, once you get beyond requiring those 2 case sites, Tamara has mentioned that some of our IP boutiques have started dragging in patents, which cite no cases at all whatsoever, and using that to see their context. So the limitation to 2 citations is something that they're going to want to overcome, and I think hopefully they will. The other thing, though, that I really don't like, and this actually really makes me angry as one of the sort of pioneers of contextual research on this, look at their recommendation tags there, right? Look here how they say, frequently cited, high court, last 2 years. These are the tags of the old world way of doing research, where they're pretending that, well, just the sort of blanket fact that somebody 2 years ago cited this is somehow helpful for knowing if it's useful for your context. Imagine if your doctor said, just take this pill, and you're like, well, why? Well, somebody took it within 2 years, so I think it must be a good fit for you, right? They're trying to inject their old ways of sort of doing ranking and relevance into this new...
That inference is good. I mean, if people are citing to that case, and they're using that case, it must have some value.
Obviously, that's exactly wrong, sir. That's exactly wrong. Because, in fact, people could have cited to it for a different context than you. So, when I was a patent litigator at Kirkland, I would work on biotech cases. And I was always upset because all the top results were always computer software cases. Why? Because those are the ones that have been cited more. Those are the ones that cited in 2 years, right? This sort of wisdom of the crowd attempt. And so then I was left to the mercy of trying to write these long Boolean queries, right, to try to convey biotechnology to this machine, right? And of course, or molecule, or protein, or gene, exactly. So respectfully, Shabir, I think you're exactly wrong with that, to say that that's a helpful. And when you see the kind of dimensions...
I take that personally.
Okay.
It's a battle.
Yeah, I guess the battle will happen after. But when you'll see the kind of dimensions that we put on our system now, what is the motion at issue, right? What is the party type? This is the parties in this litigation are just like the parties in your litigation, right? What's the underlying cause of action? Now those are useful dimensions to try to evaluate them. So, I expect those to sort of wither away, with all who sort of believe in them over time, because it's very rare. What I said to Shabir's understanding to evolve along with the field of this, right? So I think that you'll see that it's relatively rare for site count to actually be overall that useful, and we've been relying on it. We've been thinking of it as sort of, that must be the thing, because we had nothing else, because how else can you understand context except for some really long Boolean query combined with some attempt at site count. It was very crude, it's the old world of doing it, and it has no place in the future of research, or very, very limited. The other thing I don't particularly like, they say it takes a minute to run. And I'll tell you, if that happened at Casetext, we'd be filing a bug report. I mean, it'd be like in the emergency channel, like somehow Kara's taking a minute. Now, 2 things might be going on there, right? One is...
On average, a minute.
Yes, exactly. So one might be, so there's actually this sort of business psychology thing that like Orbitz does, where by taking longer, you convey that you're doing all this cool stuff. Right, exactly. I sort of hope that that's what's going on. Because the alternative is that for whatever reason, whatever service they think, they actually need a minute to do that. And I think that's I mean, come on, that's just too long. So that's a small thing, right? But I do wonder, at some point, if we can ask them, are you just trying to make us feel reassured because surely you're doing great stuff if it takes a minute? Or are things just that slow for you guys? I'd love to hear their answer on that dichotomy.
So I have a question. So the 15 cases, is it always 15 cases?
So thank you so much for that. So this is another big thing that they're going to go through, and you're going to see this with everybody. The evolution for us of how many results to show has been quite the journey. We started just showing the list.
And that's not them. No, they're this up.
Yeah. So this is like 2016, early days. And people would say, let me just make sure I understand this, entrepreneur. You're telling me I missed 1,000 cases from my brief. And we're like, no, we're not telling you that, right? So then we would only show 10, and they're like, where's result number 11? I really want to see that. Okay, right? And so you do a sort of show more kind of system. Now, when we get to Lexis's, can we call it a prototype drawing? Whatever the thing the Lexis did, you're going to see this sort of arbitrary line they draw in between strong result and broad result, right? That's how they've sort of done it, which is, of course, a very arbitrary system to use, right? And in fact, coming up with sort of like a objective scoring for this kind of stuff gets actually a little bit more complicated. So one of the reasons why we're not as worried about that kind of problem now is that we're well beyond brief analysis. We're now taking context to the full research system, letting you navigate the common law in every which way you want, be they short, very defined Booleans that only return 10 cases, or broader ones that return more. So that's sort of like why we're not as pressed by that issue. But certainly you're going to see, whenever you have AI sort of recommending things, how do you know when to sort of cut it off? Please.
Is it lying to legislation? Does it only care about case law?
So I don't know, but I'm guessing that they would be smart enough to use at least the statutes and the
You
rules.
would fool, so yeah.
Yeah,
hopefully, yeah.
right. Yeah.
One
It has
last
secondary
thing-
sources too.
Yeah, and secondary
Right,
sources, yeah.
right.
One last thing that I'll say that I like about this, we're moving off from Westlaw, is that in their reporting about it, the way they talk about it is that quick check helps you find the things that you might have blind spots for. And it's an important conversation that these kind of AI tools begin or start with, which is it possible that the old way of doing legal research with Boolean-based queries may have blind spots? Might it be that we either accept too much or have an over-inclusive set of results that then make it hard, if not impossible, to find what you're looking for, or narrow too far and potentially cut out some very relevant results because we use too precise of language in our queries? And one of the beauties of being able to use technology that can read something as complex and rich as a brief or a complaint and understand it to some level, right? To really see all the words you've used, all the citations you've used, the concepts, the jurisdiction, et cetera, and rise to the top, the most important cases, is an evolution of the way we've been thinking about legal research really for the last 2 or 3 decades. And so I think that what I like is that they're thinking that same way too, and they're asking themselves, can we help fill in known blind spots using traditional Westlaw, Lexis, Google, Casetext, et cetera, search?
And did you answer the question about how many results they return?
15.
We believe 15. They might have a show
It's
more.
not.
but-
It's not set at 15.
Yeah, so there's show more.
There's a show more.
There's a and 15 isn't even a hard number on it.
It's just whatever
what
they think,
determine
however
to be
they
the
patch
most
their threshold
relevant.
that
But
they
there is
say.
a few more cases
Oh,
like
right,
this.
thank
You
you.
can click
Yeah,
through
that
and
makes
see
sense.
more.
And just one thing to follow on that, it's not just the limitations in keyword search, right? For the longest time, we were relying on Shepard's and KeyCite, which were only direct citation path. Show me the cases that directly cite to my case. In other words, you walk into the video store and you say, hey, I like the movie The Godfather. Tell me what are other relevant movies. And they say, Godfather Part 2, Godfather Part 3. I'm done. They wouldn't recommend Casino. They wouldn't recommend these other ones, right? Now, meanwhile, Amazon... Of course, Goodfellas had. Sorry. I'd like to apologize to everyone for forgetting the most important mafia movie, Goodfellas. No, and meanwhile, Amazon, Pandora, all these other tools, the way they make recommendations for a song to listen to, Netflix, is because they're going much deeper in their citation analysis. They're looking for soft citation relationship. So that's another way. I sensed a little bit in Westlaw's marketing this sense of but we're the first to ever try to fill blind spots. Please. We would not be the dozens and dozens of AmLaw firm. We would not have the thousands of people we have if we were not filling their blind spots from the very beginning.
Full disclosure, I'm a plant from Lexis Westlaw. So they will claim, let's go back to something even more fundamental. It's where you start. And that with your data pool, they will claim, and I think correctly so, maybe not Bloomberg, but certainly Lexis and Westlaw, that they have a much faster data pool than we do, a much deeper data pool.
That's
and
right.
so their analysis and their analysis is much richer, much...
Yes,
Okay,
yes.
can we both address this in maybe slightly different angles?
Sure, but I would say they haven't read your complaint any more than we have. They haven't read your brief any more than we have. And actually, much of this is really about who can better parse the actual information that they have. The fact that they have oceans of content completely irrelevant to your context does not actually better enable them to really serve what's in your context. So I'm not surprised that that's sort of what you're saying must be the thing. But if you actually look at the results, and one day we'll be able to actually dig in and play with it, I think you're going to find that that's really specious.
Another kind of look at this, Osman Amram from Lang Case had this really, a few years back, gave this speech that I thought was really quite compelling, which was, we used to be in a time where getting just access to libraries was the main thing we were trying to do, right? And it was just about, libraries at firms and libraries at schools are just trying to acquire more and more just content, right? And we actually got to a place of information overload, where we actually have all the information, if not more, than we could ever possibly need or want or use. And then it became a question of, can I actually find what I'm looking for? And that's a challenge that we took on. So we are able to amass primary law, secondary law, briefs. I mean, if you look at the things that they're recommending through Quick Check, it's not different than the stuff that we're recommending in any substantial kind of way. It's just that we believe that what's going to really win the day going forward is not going to be the size of content, but instead, in this context of information overload, who has the best technology to zero you in on exactly what you need to find to win your case?
But you have to admit content is important.
Content is absolutely
The
important.
content that is relevant to you is important to you when you're working on it.
Yeah, no, but yes, I mean, yeah, absolutely, absolutely important. we're a 6-year-old company that has been talking about this AI product for only the last 3 years. Why is that? Well, it's because the first 3 years of our lifespan, $30 million in venture capital is more. A lot of that has gone to putting us in a position where we can say, if you were looking for something, you can find it there too. It's been an important evolution for us.
And let us put out the challenge for them to come bring us this wonderful insights that their nominal reporters from 1600 have given them. I'd be very curious to see.
Oh, we're going to go to Lexis.
Yeah,
go to Lexis. All right. So, let's talk about. We're going to go through these a little snappier because the other 2 products don't have as much or as rich of information to share. LexisNexis, before the event, before ALL, announced that they are going to be previewing, quote, AI-enabled research assistance in brief analysis, which sounds really similar. And in fact, if you guys stop by the Lexis booth at ALL, I think you'll be able to see a preview that looks not like this.
You missed an A.
Right?
That's it.
Yeah, so this might not be exactly how they'd want this demoed if they were doing it, but this is what they're doing downstairs. So I'll take this one just because I was like a kid in cancer. I was like, I'm going to see all this wonderful embodiment of this stuff that we've been working on. So I run to this when I see it. So let's start. So you see, she drag and dropped a brief beforehand. I think the brief must have had to do with a slip and fall accident. So you see some things here. They have their, from your brief, concepts and then one fact pattern. And these then are suggested search queries. That I like. We've had an earlier version of that we were using all these fancy genetic algorithms to sort of do it. Once we integrated to have you can search whatever you want, we sort of went away from that. But I think we're going to be folding back in versions of how to do suggested queries. But there's some important things to note on this. One, if you've ever looked at core terms on Lexis, they'll have like law in there, they'll have court, they need to clean that up a little bit, especially if they're going to be doing it, right? A more subtle thing, but I think is really important, is that for legal concepts, I think that there's a place for this. You have to be very careful, though, with fact pattern, because once you start suggesting, hey, this is the one keyword fact that you might want to use, you're injecting this new revolution of contextual research with some of the problems and limitations of old traditional research, right? So the best ways to really be using tools like this is a more broad, like, copyright or, latches or damages, something kind of broad, and then let the sophistication of the citation network and the full 30 pages of documents bring you to the factual stuff, right? So while it might look cool to say, oh, look, they showed zebra as one of the fact patterns, right? You're not going to get the case that talks about a tiger. I'm trying to use very relevant, things every day that you guys deal with. But then, oh, the plot. So I go, this poor Lexis rep is there, and she's like, I think she probably has some vague sense of this guy. We probably have her picture up on a wall, like, do not demo. And so I'm like, this is great, this is exciting. And I look at the first 2 results. Unfortunately, we don't have a screenshot of it. And I'm like, wow, those look beautiful. Those are like, that's exactly right. The jurisdictions are lined up. I like the fact pattern, those holdings. And I look at the 3rd result, and I think she sort of looked away for a second. I was like, okay, I'm going to take the mouse just for one quick second. And I scrolled down on the 3rd result, and it stopped halfway through the 3rd result snippet. It was a drawing. It was a North Korean supermarket. It was. And I turned to her and I said, "Excuse me." And I was like, "Is this why you weren't clicking on the other results?" She goes, "This is in development." That's what she said to me. Oh, it's heartbreaking. Come on, guys. So
I think this is a preview.
Yeah.
Just a quick thing. I asked them what software they were using to do the scan thing, and it's Adobe product, where it's just, it looks like it's real, but it's not. Because I do training videos, so I'm like, what are you using? I think that's so cool. And so yeah, it was not live.
Right. So what do we like about the drawing that they created and brought to us? Well, we like, I think legal search terms good. Factual ones, you just got to be a little bit careful. And again, but notice here, so you can't see it really, but over here on case recommendations, their decision has been, so the top one is cited in, so that's just what's in your brief, and we do that. Then there's strong recommendations, and then there's broad recommendations. And the question, of course, for them is, tell me, how does one decide whether something moves right at that division between broad and strong? And you're going to find some answer that basically comes to we made a call, we went with it, and that's how you're doing, right? And the top of the broad results are probably kind of strong, and so. So again, that's sort of when you're limiting yourself to just being a brief check as opposed to anchoring an entire legal research engine in context, this is the sort of the little games you play. And then they've got brief, they don't have it, of course, the thing is just a drawing, but you could, in theory, they're going to return briefs as well, which I think is really good.
Yeah.
Does anyone else have anything else on this Lexis situation that can add to our understanding of it?
I was just there.
Okay.
So the fact pattern, you can remove things, like in the slip and fall, it has all different kinds of things, but you can take things in and out. Like if the zebra didn't work, you could unclick it.
Okay, sure.
And
Yeah.
then we recommend different cases based on that.
Yeah, it'll
That's cool.
generate, like,
Yeah.
if you unclick any of those, it'll regenerate those numbers.
Right. So you're allowed to do ors and ands and
In
nots.
the,
Right. Yeah.
in the
they're-
pretend world.
Right, right.
Yeah.
So they've given you sort of the Boolean connectors with a sort of more tag graphical interface, which is kind of nice. I mean, that's a cool way to do
Yeah.
Boolean.
And
But
the other
again,
thing they
but
said-
don't mistake it, because if you don't have that one word, that actually is the word that matters, right? So like it might be ribonucleic acid instead of deoxyribonucleic acid. If that word's not in your bubble, now you're never going to see it, right? And that's
Right.
really the problem with just relying on Boolean.
Potentially, depending on how they use these
Right.
words.
But thank you, that's
Yeah.
Yeah, and the other thing they said is at the very top, like the highest value ones are going to get in their results, your results are gonna rely more on the top results that are the most, like what's the first one, like something condition, dangerous condition?
Right.
Is that what I said? But anyway, it's not like just occurrences of words, it's not like a keyword search.
Right, of
There's
course.
something behind it.
Oh yeah, that's well, of course, yeah, that's very good.
Very
So
cool.
we'll see what happens when they make it.
So the rumor is that this is coming out at the end of this year, but it might come out a little bit later. We don't really know. Q1 2020. Okay, yeah, that sounds about right. So look forward to potentially being able to play with it around then.
Next year.
Yeah, next year. Yeah. Last but not least, in terms of the new challengers, here is Bloomberg BNA. We do not have much on this. What we do know, thanks to reporting from Gene O'Grady on Dewey Be Strategic, is actually this has slipped into something about them stabilizing their pricing. Yeah, but in the same announcement, in the coming weeks we will unveil a new product that will leverage artificial intelligence and machine learning to analyze legal briefs. Designed and powered by our leading technologists, this product will dramatically accelerate research, thereby freeing up associates' time for more strategic.
It's almost like an AI wrote that.
So that's literally all we know about the potential new Bloomberg product. There were rumors that they were going to show it here, and my understanding is they have not.
No, they're showing it this afternoon. They're
Oh, they're showing it this afternoon.
unveiling it this afternoon.
Okay, they're having it
Okay.
this afternoon. Okay.
Right.
Yeah.
Yeah.
And,
They said they were
it's going
showing
to come out
here,
in September.
but-
The product will be out in September.
Okay.
Okay.
So then we have to update this slide, which is.
I think maybe that's for academic, for law school. Maybe they're putting it up for them.
Maybe okay. So that's
Right,
awesome.
maybe just a beta.
So I
Right.
encourage
don't know.
everyone here to find out more when Bloomberg presents a little later. Again, it's called a legal robot battle. We're doing this in the spirit of education, understanding what else is out there. So
The only other added fact I know about it is that they are sort of like the West one are going to kind of extract your argument headings out of your brief, but they're going to show them next to the physical image of the brief. So you'll have a split screen, and they'll be able to take any kind of a document. So they'll OCR it if it's not a
Good.
text
Yeah.
document.
Yeah, we of course. Yeah, that's very good, and we do it as well. So they're going to hang out with the whole brief then for a while.
Yeah. Yep.
Interesting.
that's a
Sure.
tough security decision.
I
We
thought
need
the
to figure
headings.
that
I
out
thought the
later.
headings was sketchy. They're going to.
Yeah, it may just be for the session. I'm not sure, but
Okay.
Yeah.
Very cool. Very, very cool. So those are the three primary new legal research AI tools that have come to challenge the product that we started in 2016. And so for the last one, because we are here, we're going to show quickly kind of the differences between the three that have come before, the three that are coming out now, and the original undefeated heavyweight legal robot champion, Casetext and Kara. So I'm going to...
And what about the other, like Vlex and Ross? And, you're going to skip.
So Ross lost the last battle and has actually flown to Argentina. They've never been seeing it. No, I'm sorry. We love our brothers Ross. So briefly on Ross. So Ross technically isn't a full brief analysis. We let that go last time. Ross, you upload the brief, and then it shows you the brief and says, choose a paragraph of this brief that you'd like to run as a paragraph search. It is essentially cut and pasting a paragraph from your brief and putting it in there. And of course,
into the search box,
right, and
yeah.
of course, then what you forfeit is everything that isn't in that
They weren't
paragraph.
designed to do what you're doing.
Yeah.
Exactly, exactly.
But it was kind of
They're
pitched that
different.
way. It's kind of it's
Yeah.
it's interesting because I think a lot of these technologies. One of the things that's really interesting is that a lot of these technologies begin the same way, which is with a drag and drop of a document like a brief or a complaint, and then like kind of what happens after that couldn't be more different sometimes. And that's an example where they kind of OCR'd the thing you uploaded and then you selected a piece. It was different. And actually, I'm not sure. It used to be one of the coolest things about the Ross product was that it was a free standalone product for anybody to use to site check your brief to make sure you're missing any red flags or whatever. And that actually is, I think, no longer true. Unfortunately, I think it's no longer offered for free. Although I could be wrong.
It's incorporated within the
yeah, it's incorporated
ROS
within the
product,
4-pay product.
but you can
right?
try the ROS product for free. now.
Yeah,
They-
you
they
can
just-
get a, I think, 2-week free trial of the ROS product any time. Yeah, for 14 days. But then
We actually have 3 months.
oh,
Good for you.
Yeah.
There's also, we'd be remiss not to mention the great Itai Garari and his company Judicata had a tool called Clerk, only limited to California law. And again, sort of doing a little bit different things. It would attempt to sort of grade your brief. Itai, would do a better job explaining it, but certainly they're doing things in the field of trying to analyze an entire document. So I think closer to sort of this category.
Yeah, and I actually do think that the VLEX product, which if we have time at the very end, we can go over, is closest to Kara in some ways. Yeah.
And speaks Spanish.
And
if I'm not
speaks Spanish,
mistaken,
yeah.
And it's a man's name.
Which I
so-
think we should call it Vicente. I really do wish we could sell it as Spanish name, but okay, all right.
Instead of Vincent Vicente.
Yes.
Yeah. All right. So zooming out, right? 2016, when we first unveiled Kara, the idea, not unlike where Westlaw, Lexis, and Bloomberg are doing today, is what we call it's called brief analysis, right? Drag and drop, upload a brief specifically, and then get information back about that brief. For example, what cases were missed, what cases are highly relevant, what briefs should you read next, right? And of course, Kara still does all that now. But one of the big evolutions that we went through, and one of the big differences between us and some of the other guys, and I think probably an evolution that Wes and Lexis and Bloomberg will eventually go through if they can, is to transition from just analyzing your brief to instead using the contents of a document from your litigation record, like a brief or a complaint, and use that to create a whole new search engine that is specific to you. That is, says, I understand now the facts, the legal issues, the jurisdiction, the all the relevant context of the litigation that the attorney is involved in, and I'm going to use that to try, when you're doing even the most basic of searches, you use that to try to pull up the most relevant cases, briefs, statutes, regulations, etc., that you need to read next, right?
Can we,
yeah, please,
for a
yeah.
minute, I'm sorry for interrupting.
Yeah, no, please do.
Interesting that your aim is to surface the best cases or the most on-point cases. What's your success rate? Do you have any kind of measurement, benchmark?
Yeah, so there are a few things that you can look to. The first thing that we did, because we wanted to analyze this for ourselves, is we did a blind study with an organization called the National Legal Research Group, for just legal research lawyers. And we commissioned this with 20 different lawyers and said, you have the same 3 research tasks split between them, on a copyright issue, a insurance issue, and an employment issue, I think.
Were the results published anywhere?
Yes, the results are published, and the Kara came out, folks researching the Kara greatly preferred it. 3/4 of them said they prefer, even though they've been using tools like Westlaw and LexisNexis for a long time. And this is only versus LexisNexis, because we didn't want to fund a fuller study with Bloomberg and Westlaw as well. So they were most comfortable, I believe, with that technology, and they liked 3 out of 4 of them. 75% of the people doing it said they preferred the Kara experience. They completed their task about 25% faster, which, if you look at the average amount of time an associate spends in research over the course of a year, it's like hundreds of hours, could we potentially say it?
That could be a
And-
disincentive.
For some firms, yeah. For some firms,
But also at the last thing.
yeah. And the last, I think, most important thing is that we asked them to rate the quality of their results on a scale from 1 to 5. And also, like, very specific things like fact pattern matches, the jurisdiction matches, etc. And Kara and Casetext outperform LexisNexis, I think, by 21%. So the score, our average like a 4.7, and theirs like a 4.1 or something like that, right?
You can read Lexis's response on my blog, but they won't tell you that.
Yeah, Lexis responded. They called it. Of course, this is multi-billion dollar.
Big Tobacco? Did they call us Big Tobacco?
I think they call us Big Tobacco. So it's a multi-billion dollar company. Of course, it's not commissioned their own study to look at this themselves. I think if they did, they'd probably find. I think the reason they're moving in this direction is that you find that if you use all the information inside the
This
brief
is the
and
kind of stuff that we will find convincing. This
Yeah.
is the kind of stuff that our litigators will find
Right.
That's
convincing.
true.
Yeah.
So I'm just putting it out there that this is the kind of stuff that you should be socializing.
Okay.
We did this all over his blog. It's been everywhere. We did
Read his blog.
We shouted it from the mountains. It's like on our website. This stuff is everywhere we can put it. We
No,
sort of
but
assumed
to
familiarity
Shannon's point,
among the.
if you don't know it, it doesn't exist. Right? Yeah. Another question.
I
Yeah.
was gonna ask also, you can also use Kara to scan your opposing counsel's brief to
Yes.
see
Yes.
what cases they would.
That's exactly right.
Yes.
Yeah. Yeah.
Right.
Which is probably the more strategic and far more interesting for
Yeah,
part
yeah.
of your attorney.
That's where it started. I mean, the actual evolution of this whole thing, actually the initial idea that I had was to do it in research fully, and then a happy side effect, I was like, this thing's returning results before you even enter a query, which is a pretty cool side effect to have, right? And initially it was going to be just your opposing counsel's brief, but attorneys were like, well, wait a minute, I don't want to miss a case before I file it, right? So then we were like...
And then further evolved to, I don't have a brief yet, but the litigation's begun.
Right.
I have a complaint. Can I use the complaint to find more relevant case law? And the answer, it turns out, after a lot of research and development, was yes. So to show you kind of the concept of contextual search is new and different, I think, for a lot of folks. So I want to show this to you by contrasting what would happen if you gave Kara two different contexts. One, I think, will be a recent litigation that's near and dear to all of our hearts. It is the case where Georgia sued Carl Malamud and Public Resource, or Carl Malamud, who just won an award, I think, just last night here. When the state of Georgia sued Public Resource, alleging that parts of their state code are copyrighted, right? And this is actually, so one piece of context we're going to give Kara as try to see how it works with this, is an amicus brief that we are actually amici on, urging the Supreme Court to look at this case. So that's one context. And we're going to contrast that with a separate context, which is the time that Miley Ray Cyrus was sued for a copyright violation because she allegedly stole lyrics from another performing artist from Jamaica, right? And so these are both copyright cases, right? If you're a copyright lawyer, you might end up dealing with both, but they are dramatically different. Like the kinds of cases you should be seeing with the Carl Malamud case, hopefully, are very different than the kinds of cases you're seeing with the Miley Cyrus case. So to give a quick demonstration of this, the way you use Kara, not unlike these new tools that are coming out that are the kind of the imitators, right? Is you begin by dragging and dropping in either a complaint or a brief. And then you'd specify the legal issue that you might be interested in researching. And we actually encourage folks to keep it very broad.
Is this live?
This is live, yeah. This is all
Come now,
live.
Shapir, after everything we just said. Come on, we wanted to debate you guys yelling out complaints and we go find it, but we just thought it would take too long. But
Yeah.
yes, guys, do you want to sit here and represent? Is this live?
So what?
I like your passion, Pablo.
No, man. And by the way, on the whole Pepsi challenge thing, the way to really see we get better results, take our 2-week trial and do it and use it, and then you can
2
see directly.
weeks.
Yeah.
2 weeks, 3 weeks, we'll give you 4 weeks. I love you so much. Okay,
right.
hold on, can we just be real quick? Like, so you see down here, these tags, guys?
But let's actually not start with the tags.
Not yet?
What
All
you'd
right.
expect to see, because we gave Kara the information that we want to look at the case involving Georgia and Carl Malamud, the kinds of cases you'd expect to see are cases where code revision commissions are suing Public Resource or similar things. Like this is a case from 2002, a much earlier case in the Fifth Circuit, where the plaintiff asserted that building codes, right, that came out from a private organization are copyrighted, right? And that actually is a very common thing that publicresource.org also gets involved in as well, right? In fact, couldn't help but notice that the West Publishing Company versus Me Data Center lawsuit from '86 also comes up here as well, right? So cases involving, and this is the cases you guys might remember from way back when, whether Westlaw's arrangement of cases in their reporters is copyrightable, right? So that's the kind of information that Kara is able to immediately bring back, given the context of a brief about Georgia, suing Carl Malamud over public information.
Sorry,
Yeah.
I don't mean to interrupt you.
Yeah, no, please do.
Just
Yeah.
because I haven't actually looked at this for a while. The bold text there at the beginning
Mm-hmm.
looks like a kind of a quick summary.
Oh, yes.
Now, I just wanted to kind of ask, how are you doing
Oh,
that?
superbly. Let me tell you how we do this. For centuries, judges have been writing these concise case summaries, and they've been packaging them in a very specific place, explanatory parentheticals.
Right.
And in fact, in the inaugural issue of Susan Neville, is Susan with us? In her journal, there's a paper that I wrote about harvesting and leveraging explanatory parentheticals. So what we did is we simply said, thank you, Your Honor. That's a very nice, concise summary of this case's holding. And when I first did this, actually how I met Jake, I had done this little version of it. I think I got 400,000 of them. And then the real data scientists at Casetext were like, step aside, young man, let me show you how to do this. 4.9 million summaries and counting. Every day, these pour in, written by judges. And most of the important cases will have multiple summaries. And Kara will actually choose the summary that it thinks is best for your context. And this matters because cases are not monolithic. Cases can stand for different things, right? So a great example of this, there's a case about whether or not prisoners should be afforded legal research and how much they should, right? And of course, Scalia's like, give them nothing but the chapter on habeas, right? Because he's the only one that gets to go make these deep journeys into other areas of law to talk about stuff. But one of the, like the 11th holding summarizing that case actually talked about, well, you need to give them stamps too so that they can file their brief, right? So if that was the little issue you cared about, that's the holding that really matters. So if you uploaded a brief where you were saying you need to give them stamps, that's the holding we would show for that case. So we're using this here, we use it in, we're going to go deep dive. We'll have a different thing on that. But,
That's very clever.
Thank you, my friend.
Cool.
Thank you.
How about Ross generating this on the fly?
Okay, Ross. All right. What Ross tries to do is say which paragraph in this case, in isolation, do I think kind of gets at this issue?
Or no, I think it's a kind of constructed sentence based on.
Oh god, it's even this Franken sentence that it kind of like took this thing here. They're using sort of an off-the-shelf Watson thing to try to do it. Now, I submit to you guys. Compare a Franken sentence sort of created from the different snippets with ellipses to a judge concisely conveying what the holding is. Everything you want to know about the difference between us and Ross is in that distinction right there.
Well, although I will say, I mean, Pablo's obviously the
No, that's not even like, come on, that's not even like fun. It's not even fun.
But I will say this, we actually are big proponents of everybody just kind of checking out both. And Ross will, for basically any of this room, I think, and it's online for free now, give you guys a free trial. I really encourage you to play with the technology. I've played with myself. Sometimes you generate the summary, and it works pretty well, and sometimes it doesn't. And that's my personal experience with it. Don't take my word for it, though, right? Check it yourself. I think that
good advice.
Yeah.
It depends how you define very well, but yeah,
Don't
sometimes
listen to
better than
Pablo
others.
all the
Yeah.
time.
Yeah. Pablo's a zealot advocate, which is good, obviously, but especially in a legal robot battle. But I think that they are definitely worth checking out and definitely worth playing with. Try their free trial and see what mileage you get. So before we move on to how these cases that are so obviously about the Georgia versus Malibu case, come about in this context. Before we can contrast that with the Miley complaint, kind of a few things of note that are points of distinction between the way that Casetext and Kara works and the way that these new tools, we haven't played with them yet, but purport to work. For example, of course, you can always see how many times it's been cited, how many articles have been written about it, etc. Kind of like the Westlaw tool, cited X number of times, etc. What we do, I think, that is a little more interesting is help attorneys focus in on different types of information, different ways of filtering their cases by factors that we think actually matter more. Things like, this is a case like the one you've uploaded that was decided on a motion for summary judgment. It is about intellectual property, copyright in particular. It involves, as one of its parties, a government, right? And these little tags, developed by our in-house technology, are trying to guide you to say, hey, this is a case that's about, besides being in a relevant jurisdiction, that besides saying whether it is or is not highly cited, and obviously the most important thing is just flipping through the different paragraphs.
And can we? Yeah. I'm sorry, guys, and I'll try to say this as calmly as I can. Our brothers at Lexis, our friends at Lexis, at our community at Lexis, released this thing they call the search map. It's this big bar with these infinitesimal green lines on it. And they ask you, to hunt down these lines. I call it the world's worst video game, to try to find where your things are. And it actually doesn't represent all of the things that are in the document, right? And this was supposed to be, because I think here's where it does matter. Design matters, right? Design does matter. So anyway, that's one difference. So here we just navigate full paragraph parsnips, or snippets that are full paragraphs, just like that. So, all right.
So that's one kind of, the few kind of major areas of distinction is, first of all, this operates over your entire search engine. As you can see, it's not a separate kind of quick check-like tool. Instead, you upload the brief and it organizes all of your information based on your context. And secondly, the ways you can filter are on the types of motions, causes of action, party types, timing, etc. Things that, based on our practice as attorneys over many years, we think actually really matter. As opposed to, as we very strongly believe, it is not, this case is from a high court. That may or may not be helpful to you as an attorney when you're looking for extremely on-point precedent. So let's contrast this experience with instead uploading a complaint involving Miley Ray Cyrus. And again, we're going to do that same really broad search at first. And of course, you're going to be more specific with your searches, but this is just for the purposes of demonstration. A very broad search based on a complaint. And again, here's another point of differentiation. The complaint that we've uploaded has no citations. So this would not, literally could not work with Quick Check as it is currently developed, for example, right? So Kara's read the complaint. It knows you want to focus on, of all the causes of action, on the copyright cause of action. And now is trying to find you really relevant results. This is a complaint filed in the Southern District of New York against Miley Ray Cyrus for allegedly taking, lyrics in violation of this other person's copyright. And it turns out that a lot of folks are being sued in the Southern District of New York for allegedly taking lyrics. So this would be a little pop star knowledge. Nobody's seen this version of the demo before. Yelled out. Who is Raymond here? Who's being sued as Raymond? Who's a 90s R&B fan here?
That's pretty. Damn.
Yeah, Usher. Yes.
You got it.
Yes.
All right. And
So-
actually, can you show result too? Because I just want to show.
We'll
one
get there in a
other
sec.
thing.
Yeah.
Okay,
Okay. So I mean, the point is, this is a case about Usher Raymond IV, otherwise known as Raymond in this case, who is being sued, of course, because a phrase in his song caught up, just like a phrase in Miley Cyrus's song is allegedly being taken, right? So Kara's able to find us cases that are on the same facts, legal issues in the same jurisdiction, and did that instantly. Second one.
There it is.
Yeah, is a wonderful case. It's a little older. When we first saw this result, we're like, oh no, it's from the 70s. Did we screw up? Actually, this is like a delightful case because it's first of all the only case in the Federal Reporters that we know of that defines the term mojo. And this is from the 1970s song "Got My Mojo Working," and it's a case about whether or not a voodoo practitioner from Louisiana owns the idea of mojo as a lyric in a song, right? And we can go on, right? The next song. Okay, easier one. Who's the West? Kanye. Yes. So this is a case about Kanye, Jay-Z, etc. And whether or not phrases like "Made in America" is copyrightable as a lyric, right? Or the last one I'll inflict on you guys. This is a much harder one. 90s alternative rock Diamond.
Mike.
What?
Beastie Boys?
Yeah, Beastie Boys. Yeah, Mike D.
you guys are
Yes,
good.
yes. Wow, you guys are amazing.
That is incredible.
This is a case about Mike D, Adam Horowitz, Adam Yauch, collectively known as the Beastie Boys, and whether or not their lyrics are copyrightable, all taking place in the Southern District of New York, right? And so that I think is the way that Kara works. And a few of the key differences, right, are it's able to take the whole context of your litigation and use that to make a better search engine. It's better legal research. It's not just Quick Check or what have I missed, et cetera, although it does that too. And it is the ability to take briefs as well as complaints, so to understand the language and structure of something like a complaint, to customize the search experience. And then, of course, because we're customizing a search experience, there are some things that are a little bit unique. For example, when you're looking at the citing cases to Edwards v. Raymond, Kara then ranks those two based on your context. It says, I know you've uploaded the Miley Cyrus complaint, so sometimes it's 7 cases that cite to the case you care about. Sometimes it's 10,000. And you don't want to parse through a list of 10,000 cases to see what really matters to you, right? Instead, what you want to see is what cases are just like yours. For example, the Kanye West case, Knowles Carter, again, for those of you who know it, Beyonce, right? Right. So these are all cases highly relevant to what you're working on, even when you're doing things as intricate as seeing what cases cite. Right. So those are some of the main differences.
And Jake, if I may, just real quick, one other thing to show you guys as a list is what would happen if you got rid of contextual search whatsoever and went back to how things were. And you can do that if you go instead of sort by Kara. And this gets to what?
Keyword results.
Oh yeah, keyword results works. You literally get the phone book. You get a case about whether or not you can copyright the phone book because this way of looking at it says, well, it's been cited a lot. It must be great because, this is why it's been cited so much because it's such a great, useful case. So the power of context can be seen both by switching it, but then by taking it away. And there are some moments where maybe you just want to see what the most heavily cited case is, but I think the stark difference there really shows you why this is not just a quick check brief thing, but just a much better way to do legal research.
Yeah, so, and then that's the key. In most technologies, and hopefully soon with Quick Check from Westlaw and whatever LexisNexis, I don't know, do they have a name for their product yet? Has it been branded?
Fantasy check or something? No, it's going to be called brief. They called it brief analyzer. It's like Acme, like you know what I mean, like yeah.
Yeah.
They'll have a cool
so
name for it.
with Brief Analyzer and with Quick Check and the forthcoming Bloomberg tool, which I think you'll see a preview of this afternoon, the ability to use it to influence your search engines, I don't think it's going to be there yet, but hopefully it will be soon. And being able to flip back and forth between the big case, which is sometimes useful, like what is the big most important case, and the case that is specific to your context is something that is kind of unique to us. So kind of in summation, what are some of the key differences? There are really three, and I guess I'll let Pablo speak to the
Well,
first.
I think I've let you guys know my thoughts on the matter. I haven't been exactly cagey with my views on this stuff,
Yeah.
but I
Well,
do
so
think.
what, do you like Casetext?
Yeah, so I think that I'm first of all, I'm genuinely happy to see these companies that have had a lot of influence, that do have a lot of users, starting to adopt some of this stuff. I think it's the future of research, and for all of the battling and the snark and all that stuff, at the end of the day, we're trying to make tools that help lawyers help their people get justice, right? And that's kind of soapboxy and almost obnoxious to talk about, but the truth is that it's there. And so I'm genuinely applaud them for getting into this, and I think it's not just a product, it's a category of ways of doing things, and we're going to see different embodiments with different strengths and weaknesses, which is why it's so important that people come and be very transparent and have these, we won't call it battle next time, we'll call it showcase or whatever, and maybe give them more than 72 hours notice. But the point is that that I think it's really important, and in Law Librarian, it's not for me to tell you guys about how important it is to get into under the hood and really start to see how these things work, because some of them have strengths and weaknesses. I mean, they all have strengths and weaknesses, and they vary. But yeah, so I think you guys know where I stand on this.
So three, for the record, we got wind that they're all launching on Friday. We heard that they're going to launch competitor products at Kara a little bit earlier, and that's when we sent the invitation to this event. It's been on notice for much longer than 72 hours.
And let me also note, anytime, anywhere, guys, like let me tell Bloomberg and Lexis and Westlaw, anytime you guys want to do this sort of thing, where we go under the hood, where we really compare it, where we have the audience choose queries, where we really actually show this stuff instead of putting someone there who doesn't necessarily understand the technology to play some sort of weird half video demo made by Adobe, we're game. And I want to see a lot more of that going on. I think that our customers, our clients, the profession deserves it.
So what are some big differences? One is, as we kind of been touching on just a second ago, brief analysis versus contextual research, right? A lot of the tools that are coming out now are really just about give us 2 or more citations in your brief, and we're trying to find other cases. That's important. That's where we were in 2016. That was the original CARA was limited to just brief analysis. But we hope that they take that next step too. It's very technologically difficult to do, but we think that they might be able to get there, which is moving beyond just analyze my brief, see what's missing, and go instead to, can I use your context and information to help you find the most relevant stuff as part of the regular legal research process? Everything down to citing cases. And that's one of the biggest differences between the original product, CARA, and some of these newer machinations that are coming out. The second is that, and I want especially those at firms to really press these other vendors on this, is the question of security. When we first came out with CARA, we would have loved to keep the full text or even parts of the text of the brief in our databases, not just to make the user experience better, but also for the purposes of evolving our technology faster and better, right? Not using just public sources, what people are privately uploading to the system. But we made a decision in coordination with the 40M law firms that we currently work with, that's a security risk. The security risk is, if you're holding on to the contents of that brief, then a malicious actor can find out, what Kirkland and Ellis is about to file in a pending litigation, and even if they just hold on to the headers, right? That's an issue. I actually don't purport to know what's going on behind the scenes, because they're getting kind of conflicting information. On the one hand, the results contain the headers and seem to do so over a long period of time. On the other hand, they say they destroy the brief completely. So there might be I'd encourage you to just ask about it. There might be a deeper kind of why there. The one thing I will say, just from a technology perspective, is the way that we've chosen to process the information is to never take, the brief is encrypted and uploaded to the CARA server. There it stays in what's called random access memory, which is a type of memory for the nerds out there. You will know that it's not a stable place to store information. In fact, if you lose power, for example, or somebody shuts off the machine, it's gone forever. You lose accurate representation of that information. And then it's only there for like a quarter of a second less before it's completely eradicated from RAM, right? And we've done that very intentionally because it's potentially dangerous to do something else. And if you're seeing products where the header is maintained, for example, I worry that means it's being written to disk, which means that potentially somebody might be able to break into the system and get the headers out. Even if, for example, they delete it after the end of your session, then say you have a 4-hour-long research session, that's a moment in time where the information is still maintained. So I'm not saying I know what's happening with the other vendors, and they may have a very clever engineering way around that exact problem. But I encourage folks to investigate that, as they investigated us when we came out with our product in 2016, because it's really, really important. If Bloomberg, for example, has an image, has an image of the brief side by side, then that means they're probably keeping it. The last thing, and this will be short, is this is a broader point. What we've seen from the other, from Bloomberg, Lexis, and Thomson Reuters, what kind of unites them is that they are first and foremost publishing companies that are making the evolution into technology companies. They're trying to get there, right? But the West Publishing Company began in literally, I think, 1865, like the end of the Civil War. To their credit, right, done some really amazing things in terms of democratizing access to law and information, to some degree at least, by publishing it, and made their money off of selling books initially, and have been through this, as you I think have all witnessed, this kind of transition to it's a company that's more than just a publishing company, more just offering content. And the same can be said about B&A, for example, another publishing company that is integrated into Bloomberg. And I think that one of the things you're going to see as a thematic difference between some of the newer companies like us and some of the incumbents, some of the legacy products, is that we take a technology-first approach. And so concepts like, releasing this product when we did, 3 years before the rest, and hopefully staying still 3 years ahead every single, at every single turn. Making it so that we aren't looking to gouge on price, right? It's a plus and minus we didn't cover because we don't have much information about it, except for in the case of Quick Check, is the price differential. But I happen to know, and I think you guys will probably all appreciate, that Westlaw Edge is a much more expensive upgrade to make than adding on Casetext and Kara, right? So the concept that you can liberate information, make better technology, and your better technology, because you don't have unnecessarily thousands of editors, right? For example, makes it so that you can offer a product at a much lower price point. I think is a much a very differentiating aspect of the way that we do business. It also enables us to do things like sell now to over 4,000 smaller firms as well as to 40 of the largest firms in America, because we can offer our product at a consistent, transparent, all-in-one price for really the first time in professional legal research and publishing. And so I think in a lot of different ways, you're going to see differences in how a publishing company approaches these kinds of new age products and a technology company. And a quick plug for us, and for this view of the world as a technology company, it's kind of coming back to something I said at the very beginning, is that I believe strongly that information is becoming more and more accessible and available. In fact, there's, like I said earlier, almost information overload. There are literally 1 billion pages of documents in the Casetext libraries at this point, right? And the challenge, used to be just, when, and as I think it's been almost like a shift for some folks in this room too. It used to be just, can we get all the books, and then later can we get all the electronic databases? But that's not good enough for today's professional. Now it's about not just having the information, but who has the best technology to find the right information fastest, best, and most accurately, right? The transition from the older web search companies to Google, right, represents a similar kind of transition I think we're going to see in this space. Who can find the best information fastest for you, and not just having access to all the information. That's the old game. The new game is a technology one instead of a publishing one. So that's it for the legal robot battle.
So the winner is?
Yeah. Well, by default, they didn't show up. There was. Again, like Pablo said, Pablo's obviously the attack dog here. He's very sweet.
Calling it very calmly as I see it. But can I just say one other thing? Guys, thank you so much for coming.